Cars, trucks and motorcycles in an Illinois divorce. Dividing property during a divorce can be challenging, especially when it comes to vehicles. Cars, trucks, and motorcycles often hold both financial and functional importance. Understanding how these assets are treated under Illinois divorce law is essential for anyone going through a separation. When it comes to the legal side, Illinois courts consider whether a vehicle is marital or non-marital property. If a vehicle was purchased before the marriage, it generally remains with the original owner. However, any vehicle acquired during the marriage is presumed to be marital property, even if the couple is separated or has already filed for divorce. This presumption ends only when the divorce is finalized. Dividing a vehicle is uncommon. Courts rarely split vehicle value between spouses. If a car has an outstanding loan, it's typically assigned to the spouse willing to handle the debt. Divorce attorneys usually include a clause in the marital settlement agreement stating that the spouse keeping the vehicle is also responsible for the loan. Failure to pay can result in a contempt of court action. So, how is the value of a car determined in these cases? Most cars lose value quickly, often falling below the amount owed on them. This makes calculating net worth difficult. If a vehicle is paid off and still holds value, courts may consider dividing that value. However, cars are seldom sold to determine their market worth because the effort and cost outweigh the benefit. Illinois divorce courts also don't accept internet listings as evidence unless authenticated. In rare cases, a professional may be hired to appraise the value, but this is uncommon due to high costs. For those who need to transfer ownership after divorce, the process involves updating the title and registration through the Illinois Secretary of State's office. If the car is still under loan, the title remains with the lender until the debt is cleared. No transaction tax is applied when transferring vehicle ownership under a divorce decree. Throughout the divorce, car insurance remains a legal requirement. A lapse in coverage is not only unlawful but can also jeopardize marital assets. If a spouse cancels insurance, the other may file a motion to maintain the status quo, ensuring coverage remains intact. Now, who actually keeps the vehicle? If a car was owned before the marriage or gifted, it stays with the original owner. Otherwise, during the divorce, the court may issue temporary orders about who gets to use which car. A spouse can't just take or hide a vehicle. Courts can intervene to maintain access for essential needs. You can even buy a car during the divorce. If you trade in your old vehicle or finance a new one, courts generally won't interfere. The only caveat is if a large amount of cash is used, as it may count against your share of the marital assets. Cars and extracurriculars are treated separately. To navigate this complex process smoothly, working with a knowledgeable lawyer and law firm is crucial. If you're facing questions about cars, trucks, or motorcycles during your divorce, speak with an attorney who understands Illinois divorce law. To get personal guidance tailored to your case, contact the law office of Russell D. Knight at 773-334-6311. We're located at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.